All right, hello everybody. How's it going? This is Immigration Attorney Moumita. I'm coming to you live to talk to you about immigration, and today I have a special topic for you because we have been receiving so many calls from potential clients who are in this situation. So I'm going to talk about a very special situation if you have a conditional 2-year green card and what to do if your spouse is nowhere to be found. But before I go into that topic, hi, my name is Moumita Rahman. I'm an immigration attorney. I have been practicing immigration law for the past 15 years, including through the last Trump administration. And yes, this time around things are a little bit different, but they're not totally different. So I'm going to talk a little bit more about the concerns that you may have. And if you are a current client, thank you for joining. Thank you for trusting us with your case. And thank you for your patience as well as we work through the various complications that immigration is throwing our way. If you are a follower, welcome to my channel, welcome to my live. And thank you for being here today. Let me know what country you're from. I always love to know where my followers are from. So let's go ahead and talk about what to do if you have a 2-year conditional green card, or you know somebody else that is here on a conditional green card that they got through marriage, but their U.S. citizen spouse has moved out, or they have filed for divorce, or they are no longer together. What can they do? What can you do if you have a 2-year conditional green card, but your spouse is not there to work with you on your application for the I-751 application to remove conditions? Well, number one, I want you to be aware of the fact that you would get a conditional green card if you were married to a U.S. citizen and your marriage was not more than 2 years old. And this is a very critical time for you because if you get separated or divorced from your spouse when you still have a conditional green card, did you actually know that USCIS may automatically consider that you have a fraudulent marriage? So automatically you have to do a lot more work and you have to proceed very, very carefully if you have a conditional green card, but your spouse is no longer with you, or you have moved out, they have moved out, one of you has filed for divorce. Basically, if you are no longer able to file with your spouse, you must work with an attorney because this is a critical time for you. Next, if you are no longer able to file with your spouse, all hope is not lost because there are still several ways that you could still continue the process by yourself without the help of your U.S. citizen spouse. So this is going to be done through what is called a waiver, and there are actually several types of waivers available for your I-751 application. And I'm going to talk about two of them in particular. The first is a divorce waiver. This is going to be a possibility for you to file for if you actually already got divorced from your U.S. citizen spouse. If you already got divorced from your U.S. citizen spouse and you need to basically renew your 2-year green card and get that 10-year card through the I-751, then if you're already divorced, meaning you already have your divorce certificate, a judge has already signed an order to divorce, officially divorced, then you can file for this waiver. But here's the key. Because you've already gotten divorced, USCIS is automatically going to put a higher burden of proof on you to prove that your marriage was real. Because they don't like the fact that you got divorced, right? They don't like that fact. So if you got divorced, you have to show a lot of evidence of your good faith marriage. We're talking about bank accounts, bank statements, mortgage statements, rent statements, tax returns, pictures, the whole 9 yards. But what are you going to do if you don't have a lot of that? Then that's when it's going to be complicated for you. And we want to find out if you qualify for a different sort of waiver called the extreme cruelty and battery. And this is going to be basically it's a VAWA waiver. And if you have suffered emotional abuse, financial abuse, verbal abuse, any physical abuse, sexual abuse, anything like that, if your spouse constantly held over your head the fact that they're helping you with papers, that you owe them, that they could do whatever they want, that you wouldn't be in this country but not for them, or that you are using them for a green card, or they could cancel your case anytime they want. If your spouse constantly threatens divorce on you and you have a 2-year green card and you're no longer with your spouse, now is the time for you to look into whether you can qualify for the waiver for extreme cruelty. And ladies and gents, if you have a 2-year green card, this is a very critical time for you because if your I-751 gets denied, it is automatically referred to the court for a judge to decide whether or not you should be removed from the country. So you really want to work with an attorney. We have worked on hundreds and hundreds of very complex I-751s throughout my past 15 years as an attorney, including cases where there's no evidence, including cases where the divorce happened 10, 15 years ago, including cases where my clients were already ordered deported because of an I-751 application, and including several cases where other attorneys filed I-751s for my clients, but they got them denied and they came to us and we were able to refile and get it approved, okay? So all hope is not lost. Give us a call, 212-248-7907, if you are in the situation and you are looking to find some relief. Okay, so all right, so that's my topic. Let's go ahead and see what sort of questions you guys have today. And just so you know, I am going live on TikTok, Instagram, YouTube, and Facebook. So I thank you in advance for your patience before as I try to get to my questions. Okay, I have a question from Sam saying, hello, ma'am, is it a good time to apply for a T visa? Sam saying, thank you so much for the question. I know you asked it a few times. Here's the thing, now is the time to apply for something. If you have been hesitating to get your case filed or to start a case and you're worried that there's no point in filing the case because with this administration, they're just gonna deny it or they're just gonna do whatever they want. The thing that I want you to consider is this: you're not willing to give up everything that you've done in this country or the life that you have built here in the United States just because of who is in office, right? You're still going to want to give yourself a fighting chance. And if you have a case in process, it is better than not having anything or deciding to wait to see what's going to happen next with this administration. T visa, it's still a good time to file T visa. T visa still has many protections with it that other cases may not. And including the fact that I have recently found out from one of my colleagues that a client who had an order of removal before filing a T visa, they were able to get a bond because of certain protections. Of course, this may not apply to everyone, but you know, the bottom line is that something is better than nothing. So is now a good time to apply? Yes, and I'd also ask you, is now a good time to sit and do nothing? That's the question that you really want to ask yourself, Sam. I hope that helps. And if you want to explore, you can give us a call, 212-248-7907. And Perales Magdis, I see you have the same question about, is it a good time to apply for T visa on Instagram? Yes, I would say now is a good time to file. And still, amongst all of our cases, as of right now, the T visa case is still with the shortest processing time from USCIS once it's filed. Even though it's still, I believe it's taking them about 2 years to give a decision on a T visa case. That's different from VAWA. VAWA is taking about 4 years now. U visas take about 10 years. So the T visa is still shorter. Of course, you want to get your applications in. You know, you don't want to wait another couple of years because in a year or 2 years, that processing time might also increase, okay? So 212-248-7907. Joaquina Placida is asking, is it safe to waive somebody on an I-751 based on abuse? Absolutely. We just got an approval last week. We're getting approvals every single week. I think that we are one of the few law firms in the country that files as many I-751s as we do. I don't think there's a lot of other law firms that file I-751s based on abuse, and we file a lot, and we have seen so many cases. We've gotten a lot of I-751s approved without interviews, but the truth is that we are getting a lot more interviews now. We've had a whole bunch of interviews on I-751s. We just got another green card approved last week or the week before for a client for whom we filed an I-751. She had an interview, then she had an RFE after the interview, which was very interesting, but we still got it approved. So the bottom line is, though, if you have a 2-year conditional card, you're not with your spouse, or your spouse is constantly kind of threatening you or trying to blackmail you to file the removal of conditions, or you've divorced from your spouse, or your card has expired, it is time to look into a waiver. It's definitely much safer than not doing anything. That's the thing that I want to impress upon you guys today, is that people, I get it that you guys are scared. I get it that people are worried about what's going to happen if you file. But if you don't do anything, if you don't have anything filed at all, and you still get arrested for something, that's not going to be of any help to you. So it's much better to have something in process, to work towards a goal, to be with the protection of a law firm that can advise you on things that you're going to be worried about, than to do this alone with nothing. Okay, 212-248-7907. I have, oh, KK. I'm a current client we spoke 2 days ago. Just hearing your voice provides so much hope to me. I'm so glad. I can't remember who I spoke to. I'm not, I have a feeling I know, but I'm glad. Thank you so much, KK. I'm glad to hear that seeing me here gives relief. And I know I have not been going live as often because the truth is I've been really, really busy. We've been so busy. We've been working on lots of requests for evidence because one thing that I want to let you know is that here are some of the things that have changed with immigration. These are some of the changes that we have been seeing so far this year, especially the past 4 or 5 months. I would say these are the biggest changes that we're seeing in immigration. Number one, lots of requests for evidence. We are getting requests for evidence on a lot of our cases. Our cases are very strongly built. And we're getting requests for evidence even on cases where we gave lots of evidence, where we gave lots of detailed affidavits. But does this mean that you should worry? And the answer is no, because they're going to do whatever they want. They're going to try to clog up the system and give requests for evidence. What happens later is who's your attorney going to be that's going to file the response? Because if you have attorneys who are not good at responding to requests for evidence and they don't know how to fight back against whatever it is, whatever BS that USCIS is saying is wrong with your case, then that's where you're going to be in a tough spot, right? So what matters, it doesn't matter if you get the request for evidence. What is really more important is how your legal team handles their response, right? How do they handle the response? How do they fight back? How do they put together an even stronger response, right? That's the first biggest change that we're seeing. Next, we are getting lots of interviews. A lot of our, we're traveling almost every single week for interviews. It's a good thing, but it's also, of course, stressful for clients to have interviews. And the next thing that we're seeing is that obviously we're always having to deal with changes. So for us, it's taking longer to sometimes work on cases or to get things out. And even when we file cases, it's taking a longer time to get receipts back. I have a question here from Asif, who's asking how long should one wait to get receipts for VAWA? For VAWA cases and T visa cases, we're seeing an average time of about 4 months to get receipts back. Okay. So anyway, that's what I wanted to share with you today. Miss Maria Chavez, I sent in my I-485 5 days later in my USA's account. They say that I'm a final step for decision because they're going to use my old fingerprints. Does that mean I won't have an interview? Wow, that's really fast for you to be in a final decision. Maria, I don't know if that means you're not going to have an interview. It could still mean that you're going to get an interview. It just means you don't have to go give your biometric notice. Also, just because it says that you're in the final step, it doesn't mean that you're going to have that step completed right away, right? So a lot of times when you file your case with USCIS, you might see the update online that says that your case is ready for an interview or your case is ready for this stage. It doesn't mean that you're going to have your interview. You might still end up waiting 6 months to a year for your interview, because all that simply means is that you have reached the stage where you are going to wait in line for your interview, okay? So I hope that helps, Maria. Pesa mucho, thank you so much for the flowers. Kamarla saying, I-130 filed in 2022, approved for a child under 21, approved in May. How long for NVC priority date? Kamarla, I can't answer that because priority date calculation is something that's a little bit complicated that I cannot do off the top of my head. So I'm sorry about that I can't help with that question. Peso mucho, would it be safe to travel international with a combo card? I'm your lawyer. Hi, Peso. Thank you so much for the question. So here's what I say. I just spoke with a client today, one of my clients. We have her interview next week. VAWA client from Mexico, unlawful entry. And VAWA's approved, and we have her interview next week for her green card. And I actually found out today that my client is traveling a lot, like almost like more than once a month on her advanced parole card. And she's had no problems at all, right? She's had no problems. However, I tell clients that, you want to be a little bit more, you want to be cautious, because the problem is that, when you're traveling on advanced parole, the minute you step outside the country, you are at the mercy of Customs and Border Patrol to let you back in. And if they're having a bad day, if they don't like something about you or your case or whatever, they suspect something, they could absolutely deny you re-entry to the United States. And is it safe to travel? You really have to kind of go with your gut. If you feel any anxiety about it, I recommend that you don't travel. If it's a true emergency, of course, then go travel. But if you're just doing it for like fun or for vacation, then I would say, I would feel better knowing if you were traveling when things have died down a little bit more here. That's what I would say. But of course, if you have to travel, if you have an advance parole, you can. You just have to understand that there's always that minor risk, okay? And especially if you are somebody who has any sort of criminal history, any previous immigration court history, any orders of removal, anything difficult in your case, I especially then do not recommend that you travel, okay? But yeah, like the results vary. Like majority of our clients have never had a problem, including this one client who's traveling even like a few weeks ago. But we have had some other clients have some problems, and I've heard of some other stories of clients not getting allowed in, okay? Not our clients, but other people, okay? I hope that helps. Te deseo mucho. Muchas gracias por su pregunta y las rosas. Okay, Mehdi's asking, I came to the US and then I did my interview and got a credible fear interview in 2025. I married with a US citizen. What's the process? Can I adjust my status from here? Mehdi Hassan. Mehdi, thank you so much for your question. Now, if you entered the country through the border, and you are now married to a United States citizen and you want to get your green card, the process is just not that simple because of the fact that you came in through the border. Because you came in through the border, you lack what is called an entry with inspection. And without that entry or inspection, you're kind of ineligible to do adjustment of status in the United States. However, there's a couple of ways that you might be eligible to get around that. Number one, maybe you actually have a parole stamp in your passport. If you actually got paroled into the United States, then you could use that to adjust. Number two, if you are willing to leave the United States and do a provisional waiver through the form I-601 before you leave, then you could still get a green card. You just have to leave the United States to do an interview overseas. Or next, you can try to continue with the case that does not require you to show the legal entry. For example, if you are doing a T visa or asylum or a VAWA case because your spouse is abusive or your adult U.S. citizen child is abusive, then that could be a way for you to get a green card without having to leave. I do want everybody to understand, though, that if you get married to somebody after the U.S. government has started a removal process against you, after you're already in court, you have to prove at a higher standard of proof that your marriage is real, because they kind of automatically assume that your marriage is not going to be real if you get married while you have removal proceedings already started, okay? Next, another way that you might be able to fix your status without having to leave is if your U.S. citizen spouse is in the military, right? Maybe they're in the military, maybe they're a vet, and you might be able to ask for something called military parole in place, okay? So these are kind of the ways that if you enter the country through the border without permission, unlawfully, illegally, but you're married to a United States citizen, these are some of the ways that you could fix your status. You basically cannot do it the straightforward way. You cannot do it the easy way because you made that big immigration violation, okay? Mehdi, I hope that helps. You can give us a call, 212-248-7907. And I do want to let you guys know that my team is standing by. If you want to make an appointment for a case evaluation to see if we can help you with your immigration case, please call us right now. Our telephone number is 212-248-7907. We are dedicated to finding those solutions that other attorneys don't look for. It's one of the things that we pride ourselves on. So we hope that we can help you. Give us a call, 212-248-7907. We do have a $150 case evaluation fee, which is basically we'll give back to you if we don't work together, or we'll apply to your case as a credit. So you've got nothing to lose, okay? And we work with clients all over the United States, no matter what state you're in. We want to help you have excellent legal representation, okay? Jess, if I fly from Arizona to Long Beach for a funeral next week with just my Mexican passport, will I be okay? Jess, Arizona's a tough spot. I was traveling recently. I think I was in Arizona, actually. I flew through Phoenix. And definitely they did like extra TSA checks, and definitely I know that they must have been ICE agents that were waiting outside the plane. So if you're flying through Arizona, the Arizona airports, tougher enforcement. I wouldn't recommend it. So it's very difficult if you have a Mexican passport. If you have other, if you already have a case in process and you have a valid EAD, maybe that might be okay. But without that, I definitely would not recommend that you travel internationally through Arizona. Maybe there's another way that you can get there. Okay, I hope that helps, Jessam. And I'm sorry I couldn't give much better news about that. Okay, let's see. Can I apply for a T visa if I'm abused from my employer and I have a valid EAD from Salim? Salim, absolutely. It is a common misconception that a person may not qualify for a T visa just because they're working already with a work permit or just because they are receiving more than the minimum wage and are on payroll. Let me explain to you what is required to get approved for a T visa. Number one, if your employer is basically exploiting you and abusing you, they pay you very little, they make you work all hours, they don't let you take breaks, they don't really let you take sick days or get care from a doctor if you get hurt on the job. Those are some of the things that may be happening. But also, the second thing that we have to ask is, does your employer constantly kind of threaten you a little bit and get you to work? Because, we had a T visa approved for a client who worked at a nail salon, and she had an EAD already because she'd filed for asylum, and her employer still made her believe that she'd get in trouble if she didn't listen. If your employer makes you feel like you're gonna get in trouble somehow, you're not gonna be able to find a job elsewhere, if you might still get in trouble with immigration or with IRS or someplace else if you don't do what they say, those are threats that are used by your employer to get you to do work. It doesn't matter if you're working on the table with an EAD. It doesn't matter if you're getting paid minimum wage. You can still be paid minimum wage and your employer can still traffic you for your labor. And I want you to think about it this way. If you have ever been in a situation where you're not really working of your own free will, you're working out of fear of how your employer can mess up your life if you don't do what they say, that is going to be the core essence of what is labor or human trafficking, okay? And if you have ever been in a situation that sounds remotely like this, please give us a call so we can help look into your situation. Our telephone number is 212-248-7907. Okay, Salim? I hope that helps. Okay, Abby, I am your green card client. Thank you for being a client. I have 2 bona fide notices of work and travel permit, and I'm a DACA recipient. Is there any update on a green card timeline? So if your case was filed in 2023, so what I can say right now is that lately we have been getting requests for evidence and also RFEs and also interview notices for cases that I filed in 2021. So it's roughly 4 years, maybe a little bit less than 4 years, but roughly 4 years is what I would say now for in total for a green card from VAWA. Okay, I hope that helps, Ambi. Do not pollute. Do you think there will be more progress with F2A in 2026 visa bulletin? I really don't know. Honestly, I have not been following the visa bulletin that closely, so I don't have any predictions about that. Okay, do people have a risk on that also if your case is not filed yet? From Vanessa, thank you for the question. If they will be stopped by ICE. The truth is, Vanessa, everybody has a risk right now, whether your case is filed or whether it's not filed. So if your case is already filed, that does not prevent you necessarily from getting stopped by ICE or picked up. That is the unfortunate reality of how things are different this time around. But what I mean to say is that even if you get stopped, if you get put into a deportation process, if you have a case filed, that's something that we're going to be able to use to try to get the court to see that you're trying to do things the right way and to get you to get a little bit more leniency in your case. So that's really what I mean, Vanessa. I hope that helps. Okay, Jesus, hello, nice to see you. Jesus says, my 4th prima facie is 3 weeks late. Does that mean that my case is now being checked by USCIS? From Jesus? Jesus, no, it just means that they're late with the prima facies. I have to be honest and tell you that USCIS seems to be pretty understaffed and pretty overwhelmed. First of all, they're taking 4 to 5 months to give out receipts. Okay, in addition to us getting requests for evidence on cases, we've at this point we've received like 4 requests for evidences on cases for which we already submitted a response for a request to evidence like months ago. So they're sending us the same request for evidence, even though we already replied many months ago. They're just a little bit of a mess right now, I would say. So if your prima facie determination letter is late, it's not because it means something about your case. It probably is because they're not really working as well as they could, to put it nicely, to put it mildly. Okay. Asa here is saying, hello, everybody. Wish you all the best in your immigration journey. Thank you, Asa, for that. Canadian citizen trying to move to the States from Bankstar? Why? Things are good in Canada, man. I entered the U.S. parole in 22. A year ago, I get married. My spouse is Cuban with a 10-year green card. I already submitted my marriage-based case. That's good. You probably qualify for Cuban adjustment of status. There's a lot of protections in there. What if the employer worked you for 9 months and never paid you, and when you asked for money, they fired you? Tony's hobby channel. That's a good question. Well, number one, Tony, if you're working for somebody for 9 months and they never pay you, they probably told you they're going to pay you, just keep working, they're going to pay you, right? Am I right? And they're probably lying to you. And fraud is a way they get you to do work, and fraud qualifies. False promises, fraud like that basically is also a way that they get you to do work, and that qualifies for trafficking too. But I bet you your employer who got you to work for 9 months without paying you, it was more than that. And I bet you there was some other stuff going on, and we would love to discover that for you. So give us a call, Tony, 212-248-7907. Brenda Lopez Mejia, can you explain cancellation of removal once VAWA is approved if one doesn't apply for a green card? Okay. So cancellation of removal once VAWA is approved. So if your VAWA is approved, you technically, you shouldn't need cancellation of removal unless you end up in removal proceedings. Okay, so if you're in removal proceedings, there's two things that you might be able to ask for the judge in order to help get a green card in court. And that is going to be cancellation of removal and special rule cancellation of removal. Special rule cancellation of removal is actually a VAWA cancellation of removal. So it's kind of like you get to do VAWA in court, but it's actually a little bit different because we don't have to show good faith marriage, and we don't have, like if you got divorced more than 2 years ago, you can still qualify for VAWA cancellation of removal. And basically you kind of have a trial with the judge, and if the judge agrees that you qualify, then you're put in line for a green card. And cancellation of removal is a little bit different. You have to show that you were in the United States for at least 10 years, and you have either a spouse, parent, or United States citizen relative who would suffer exceptional and unusual hardship if you were to get removed. So it's a lot different than VAWA cancellation of removal. So anyway, if you do end up in court, if you do end up in court and you have been in a marriage that was abusive, even if it happened a long time ago, you may qualify for cancellation of removal in court. And next, if you end up in court but you don't have a marriage that's abusive, or you only have a U.S. citizen child as a relative, you may be able to do cancellation of removal in court to show that your child would suffer exceptional and unusual hardship, and that's why you should not get removed. So even for those of you who end up in court, I want you to remember that sometimes there's always still a way. There's still a way to continue fighting, okay? That's the thing. We've got to continue fighting because we still have 3 years left. And, I'm hearing too many people saying, unfortunately, that they're going to give up and go home, which I understand, but I want everybody to consider the fact that in my belief, I do believe that these things that they're doing are going to slow down and die down at some point, because they're not necessarily going to be able to keep it up, and it may not be that worth it for them politically as well. So I don't want everybody to close off their minds to the other ways of getting through all of this, okay? 212-248-7907. Okay, guys, so that is actually all the time that I have for today. Thank you so much for joining. I hope that this was useful. I hope I helped explain something new for you today, or I helped give you some reassurance about your case, your possible case, your case in progress, or about what might happen should you get picked up, okay? So again, my name is Moumita Rahman. I'm an immigration attorney, and If you do want a case evaluation with our office, give us a call at 212-248-7907. Okay? Thank you. Good night, and God bless.